not guilty by reason of self-defense. But I think you're doing a great job for it, being one of your first times, and I think you'll become more comfortable on the computer stuff. So thanks for going first too.
All right, thank you.
All right. I will also say that the open and close the contest is actually going to be in person. So you guys get comfortable, whenever you write this, whenever you're practicing it, wall talk it, do it in front of a mirror, get your, work on your presence. It'll take you a long way, and it helps you get comfortable in actually doing this. So that is true. Yes, unless you have an accommodation, as Brittany says. Brittany's always keeping me in check. So if anybody just has to do it online, just let us know, and we'll definitely let you do that. All right, next one up. Does anybody want to volunteer? Anybody at all?
I can go.
And who is that?
Oh, I'm Emily. Sorry. Hold on.
All right, cool.
I took your advice and I stood up, so hopefully that'll.
You're fine.
That helps a little bit.
All right, go ahead.
Let me pull this back up. I'm sorry, I don't know where. There we go. Ladies and gentlemen of the jury, I wanted to take a moment to express all of our appreciation for your time and attention through this matter and your willingness to actively listen to both sides. You've heard a lot of evidence throughout the trial. At this point, you may have already made a decision about whether or not my client violently murdered her husband on the morning of March 8th. However, this case is not a question of if Lucy killed her husband, but if she was rightfully acting in self-defense when she did. This is a case that the state is attempting to make an example out of a woman who was a victim in the situation, and in defending her own life, did what she needed to do in order to make it out of her home that day. As I stated to you at the beginning of trial, I am not required to prove that my client is innocent. The state has the burden to prove that my client is guilty beyond a reasonable doubt of first-degree murder. Simply, that requires willful, premeditated, unlawful killing of another person. Not one of those elements is true, nor has been proven by the state in this case. With that, we're asking for you to return a verdict of not guilty on the first-degree murder charge based on the evidence that we as the defense has presented, as well as the state's presentation of evidence. Throughout the trial, you heard testimony from my client's daughter that her mother and father were verbally arguing in the morning before she left for school. And before she left, the situation had calmed down. You also heard testimony from a mail carrier who, while in proximity of my client's home, heard her screaming, "No, please don't do this," which proved so alarming from outside the house that he was compelled to call emergency services for her. You saw and heard evidence that exhibited that my client had defensive wounds on her arms and hands and bruises, and went in a panic, claiming, "This was all an accident and he attacked me, I had no choice." As a woman in shock who had just accidentally killed her husband, the man that she promised to spend the rest of her life with, the father of her child, she was exclaiming that she had no choice. This does not prove premeditation or intent to kill. If you can recall, one of the reasons I pointed out at the very beginning of trial was for you to make a decision about the future of Mrs. Lucy Johnson. This is a woman who has suffered a grave loss and even further is being painted as an aggressive criminal, which is entirely inapplicable given the facts that have been presented to you. My client is a victim. Additionally, she lost her husband, she's a mother who lost the father of her child, and the state has failed to meet their burden of proving beyond a reasonable doubt that my client is guilty of first-degree murder. Therefore, we would ask for you to render the only verdict that is fair to her, which is not guilty. Thank you.
All right, thank you. Adam, you want to, yeah.
Hey, Emily. I think you did a good job. I thought it went really well. I think you did a good job of explaining, the basis for why the self-defense was there, using some facts of the screaming and the evidence of, what the mailman said. And I guess a couple of things. One, for everybody, typically in these scenarios, talks a little fast, right? So you're kind of like, it's okay to pace yourself and maybe have a little more inflection with your key points that you're going to be making, right? Like when you say, she is not a victim, she is, you're like, she is not a victim. You know what I mean? Like you really need to, you're going to emphasize the really important parts of it. But first time, 1L, I think you did a really good job.
Emily, what's up? I like your clothes, and one of the things that I really liked about it was the fact that you decided to you made the decision to emphasize that she's the victim here. She was the one who was being attacked. She was the one who was in danger, and she is the one who rightfully defended herself. So you made that distinction, and then you also hit on the fact that the prosecution has not met their burden beyond a reasonable doubt. And especially within the limited window that you have, you hit another thing that I like to do is also like a jury charge at the end. So you should make a verdict that is only made possible by the facts and the evidence as they've been presented, and that lets the jury know that they're not to use any outside sources, or not to use any other extemporaneous items, I guess, to come to their conclusions. It's only solely on the facts and the evidence, and the only one that matters is not guilty, because that's what the facts say. And I really like that. So good job for your first attempt at a closing. It's great. Hope to see more from you.
Hey, Emily. Great job creating your closing statement. One thing I would ask you to try is you refer to the defendant as your client multiple times. The whole, as the defense, you're trying to really make her human to the jury. She is just Miss Johnson, Lucy Johnson. She is a person just like you and I, and in this situation, she responded just like you or I would. She acted in self-defense. So really try inserting her name once in a while to make her seem more like a person, and not consistently reminding the jury, oh yeah, she's a defendant, she's a client in this murder trial. I liked how you used the testimony. I know in this situation, you weren't given, for example, a deposition. And obviously we didn't have a trial, so you couldn't take actual quotes from testimony, but I could see how you would into your closing statement.
Awesome. Anyone else have any other comments?
I'd like to pop in for a bit. Hi, I'm Nathan. Oh man, but I just want to go off something Adam recommended. Whenever he was talking about your inflection, you wrote into your script great emotion, but you didn't capitalize on it. You have the ability to write; it's there. You have like really good ability to get those emotional moments and just capitalize on it. And of course, when you're actually up there, you're not going to have the scripts. Be ready for that. Other than that, though, it was a very good job from 1L.
Thank you, Nathan. Anybody else have any comments? All right. Thanks, Emily, for presenting. Anybody else want to go? Next one up.
I believe
I
that
can go.
Matthew said.
I got you. Go ahead, Matt. Show us what you got.
Can you hear me? Well, I assume you can. Okay. So I'm continuing on with the defense as I did in my opening. So, members of the jury, today you have heard the state's best argument that Miss Lucy Johnson committed the high crime of first-degree murder. You've heard them try to prove beyond a reasonable doubt that Miss Lucy Johnson premeditated the murder of her husband. Now, premeditated murder means that she planned for this murder. She may have been even laying in wait for this murder, that she ambushed, or that she did something that shows a calculated move to bring about the murder of her husband. And mind you, the state had to prove this beyond any reasonable doubt. But when the facts were presented, they couldn't prove it at all, yet alone beyond a reasonable doubt. For this notion that Miss Lucy Johnson preyed upon her husband and pre-planned a murder of her husband ignores the realities of that while Mrs. Johnson and Mr. Johnson were in a marital dispute, that there came to a point where Mr. Johnson approached Mrs. Johnson, and there was a impassioned pleading, even a begging from Mrs. Johnson that her husband not attack her, that her husband stop making these advances on her, that her husband
Hey Matt, you kind of cut out. I'm not sure if it was just me, but it's Brittany.
Yeah, Tuttle, your audio's out.
Maybe because of the thunderstorms going on.
Maybe. Matt, how about you try to go back out, come back in, see if that helps. So the tryout is going to be over the course of 2 days. First tryout's going to first one day is going to be the opening statement. We're going to give the opening to one of the cases that we decide it's going to be a civil case because I realized that it was kind of unfair to make the 1Ls do a criminal law fact pattern, but here we are. So I was going to do a civil case. I'm going to try and I've got it narrowed down to 2. I guess me, Celia, and Bree were discussing that a little bit. But the second day is going to be the closing argument based upon the same fact pattern. You can either do it from the prosecution or the defense side, same as we're doing here. Only you guys will just be a step ahead. You guys will actually be able to, be ahead of the game for most people who tried out or who didn't do this practice. But yeah, you can also do it in person, or you can do it online if you're more comfortable with either one. That's completely fine to us. But it should be a fun time. It should be great practice for everybody, regardless if you make the team or not. I guess if anybody has any other questions on the actual tryout, just feel free to ask.
So they are in person, and what's the rule then for notes? Are they allowed to have bullets with them? Are they allowed to actually bring their script? What's that rule for on your end?
You should. Now, I don't want to create like a hard and fast rule of just no notes. Obviously, the more prepared you are, the less on notes you are, the better. The times of that will be 12 to 2 on a Saturday and Sunday. We try to do a Friday, Saturday thing, but the schools close on Friday nights. But yeah, when it comes to notes, if the more off notes you are, the better. Because it shows a level of preparedness. It shows a level of how much you put into it, and it shows it shows work ethic. We want people who are going to actually, when it comes to competition time, you're going to do the work. You're going to make sure that you're prepared, and helps out your team. But if you're on notes, it's not that bad, not a big a deal either. I will say, if you are mainly on notes, a little trick of the trade is just work on the presentation. Work on your inflection in your voice. Work on placement, movements of your body. Certain steps that you take while you're talking. All those kind of things helps, especially if you're deficient in one area. Yeah. So just try that. Try out a couple of things that work for you. Like I said, wall talk it. Wall talking helps me a lot. I do it. I usually do this method where I memorize paragraph by paragraph. That's how I memorize my closings. And then once I memorize it, I'm able to speak extemporaneously based upon that. So if anybody has any other questions?
I was piggybacking off a presentation. Do you have any tips for them on how to dress for a mock trial competition?
Wear your super suit. That's what I like to call it. Wear I know for guys, suit, tie. I guess Adam could talk more about that too.
You knew I was going to chime in there, didn't you?
You already know.
Yeah, it's one real simple rule. Guys have to wear dark suits, dark gray, charcoal, navy. I mean, black's fine, I guess, if that's all you've got. None of this pastel business. No bow ties. No, sir. No bow ties. I'm looking right in the camera on that one. Ties need to be very, very plain, like this.
Adam would
Right?
have
Like
he would
that.
have some
Like
examples.
that. Oh, dude, I got a caddy for all my stuff over here,
But what about
No, for real though. Yeah, you want to be wearing stuff. I'm saying this for sure though. You definitely don't want to wear anything other than white button-up shirt, light blue button-up shirt, maybe. Definitely solid suits. I wouldn't go big pinstripes. I mean, it's just the point is this. You don't want someone judging you other than what you're doing. And if you look in any way that someone could potentially think is weird, then that will enter their mind. So you want to be just super put together. I mean, I'm talking like press sharp, but you're not doing anything flashy. There's lawyers I know that don't even wear their nice watches because they just don't want anything to distract from what they're presenting. For females, very similar in that, no bright colors, no high skirts, suits, suit jackets, clothes, that fit fairly well, but not too tight. In the courtroom, it's hard to get around with high heels. So most of the girls that I see that do this wear flats or maybe like a little bit of a riser. But again, the point being, you don't want anyone to think anything about what you're wearing or how you look other than you look like a lawyer. So that's my 12 cents.
Awesome. Thank you, Adam, as always. Matt, I guess, are you good to go?
Can you hear me better now?
Oh, yeah. You're good.
Good. So I don't know where I let off, and because I'm a procrastinator, I didn't write any notes for this either. So do you want me to start from the top or just roll on?
Let's go ahead and start from the top.
Hey, Matt, why don't you do this? Your video
Yes, sir.
feed is not very good. So why don't you just pause it and just say it? Because it's like delayed.
Okay, let me just turn off the video. Is that okay?
Yes.
Good. Okay. So, as I said before, I took the side of the defense for the closing, just as I did for the opening. So, members of the jury, thank you for being here today and listening so intently. Today you heard from the state their best argument that Miss Lucy Johnson committed the high crime of first-degree murder against her husband, Mr. Johnson. They gave their best evidence that she committed a premeditated act of murder. Now, premeditation means that it was pre-planned, it was thought out, that she calculated on how she was going to kill her husband. And the state had to prove this beyond any reasonable doubt, that to the point where no reasonable human being could question whether or not that happened. Members of the jury, that's just simply contrary to what all the evidence shows. As you remember in my opening, we know that Mr. and Mrs. Johnson were in a marital argument, as so many of us have in relationships, and that it got heated. And then you learn through the trial that Mr. Johnson approached Mrs. Johnson and was physically violent towards her. The evidence of that was shown through the bruising upon Mrs. Johnson. Then you heard testimony from a mail carrier who was in close proximity to the home, hearing an impassioned plea, even a beg from her husband, that he stop attacking her, that he stop hurting her. And then there were the gunshots. The state would have you believe that Mrs. Johnson calculated, planned, and purposely set up the murder of her husband. And they would like for you to agree with them in that regard. But friends, that's simply just not what happened. Every piece of evidence shows that Mrs. Johnson begged for her husband to stop attacking her. And when the attacks continued, she was left with no choice but to end the attacks herself through the use of lethal force that sadly resulted in her husband, whom she loved, the father of their daughter. It resulted in her taking his life. This isn't fair. It's not fair that you're being forced to make this decision. And it's not fair that Mrs. Johnson, who is in a situation of fear for her life, must come in here and defend against allegations that suggest that she planned and that she purposely ended the life of her beloved husband. I ask as you deliberate today that you remember the facts, you remember the situations which she was put in, you remember her cries and her begging that her husband stop his assaults. And then you return back to the only verdict which is just, the only verdict which fits, that she is not guilty of the high crimes that the state accuses her of. Thank you.
Awesome. Yeah, Adam, you can go first.
Matt, you there?
I am here.
Hey man, that was really good. Thought you did really well. You seem super comfortable. Have you done this before?
Not so much this, but I've done a little bit of public speaking.
Yeah, you've got good pace with your words. So I think you did a really good job. I mean, honestly, I don't know if you all know the elements of first-degree murder. Is that what she's charged with, Wes?
Yeah, first-degree murder.
So it's got to have the intent to kill kind of thing behind it.
Oh yeah.
All right. Well, I thought you did good with that, Matt. I mean, I've just kind of looked at this sheet just now, so I'm kind of looking at what your evidence is. The only thing I guess I'd mention, you know, when you're kind of like Emily, you're gonna want to get after some of these important points. And there's some quote in here where it says, "No, don't do this." You know, when you're talking about the mailman, you know, you may want to screen that, right? I mean, that's a big
Very
one.
good.
And then I guess at the end, you know, with the fairness thing, I mean, there's nothing more fair than a jury trial. I mean, that's what's so fair about our system, is that you get to decide as a jury whether or not someone goes to jail for their life. And so I'm not a huge fan of not fair. I mean, I get what you're saying, right? It's not fair she's dragged into there. But, you know, keep in mind that you've got to be very intent on every word you use, right? So you just got to be thinking through those kind of things, because fairness has a broad brush. And so, but otherwise, man, you did a really good job.
Matt, so like you said, you were very I guess relaxed when you give your opening. Sorry, the thunder is deciding to rattle my entire house. So I like the way you set the tone. Essentially just stood up there, and you know, usually the prosecution will come up there with their fiery rhetoric and, you know, wanting, you know, to put this person under the jail. Well, you got up there, you were slow, you were methodical, you laid out the evidence, you laid out the points that you wanted to hit, and you talked about how horrible this crime was, but you also talked about how much you also talked about how, you know, it was horrible that she had to defend herself in this manner, and it was really effective. So I like that. So it was a very good job. And like I said before, I don't know, your voice is one of those that you should probably just, you know, leave law school and start reading audiobooks and make a ton of money. So, but otherwise, good job, man. I really appreciate the effort. I don't actually really mean quit law school, but I'm just, you know, it's a joke.
That might be great advice, honestly.
Hey, Matthew. If I could give you kind of the other side of the coin to a piece of advice I gave to Emily. To her, I said, try to bring in your client and make your client as humane as possible. Sorry, I keep saying human as possible. I think you did a great job of that. But I would be careful to bring her or your client into situations that aren't in the case. Some things I wrote down that you said when you're talking about the premeditation and types of premeditation, I thought that was great. You gave examples of what premeditation is. That would mean she'd be outside lying in wait. That means that she would have been planning this for a long time. I would suggest to you that those are times where you'd want to leave your client out of it and say, you know, premeditation is when a person or when one lays in wait, kind of separating her, because we don't want to give them more reasons, more kind of like images of your client who's this victim of domestic abuse to, you know, have this image in their head of her laying in wait, waiting for a moment to just kill her husband. I did like how you broke down. You did a really great job of breaking down what is premeditation. I think you did a good job as well of reasonable doubt. I think everybody could hone in more on reasonable doubt and talk about how this is such a high bar. And it is our, we have shown you that the prosecution has not reached their high bar of beyond a reasonable doubt. We could have said nothing today and they still would not have reached that high bar. And it's a high bar for a reason, because, you know, blah, 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 blah. To you, and if Emily is still on the line, I heard this in hers as well. Try not to use in your first lines, you say like, she's charged with violently killing her husband. try to take away the dramatic language in those instances. You know, she did kill her husband. That's not in dispute. And maybe in a case where it's like, you know, it's our opinion, she never was there. She was in Nebraska the whole time. She definitely didn't kill her husband. It was violent murder. She couldn't do that. But the fact is, your client has admitted to doing it. So there's no fact that the guy died. But you want to take away any imagery of it being a violent thing. It would be your opinion through like expert witnesses that she did the very minimal amount of defending herself to reach the goal of defending herself. She used as little violence as possible because her only goal was just to get away from the guy, not to kill him. Yeah, that's it. Great job.
Awesome. Thank you, Bree, for those comments. Does anyone else have anything to say? If not, we'll move on to, I got Nathan, go ahead.
Tuttle. All right. So I liked your voice. I like that timbre. You were comfortable. You were calm. Your voice will have the effect of calming a jury, but do not be afraid to use that emotion. Don't be afraid to build that arc to your performance, because this is a performance as much as it's an argument. Don't be afraid to get emotional with it. The pauses are really good. I cannot sing enough praises on how well and how eloquent you sounded. It kind of made me think of Atticus Finch a little bit, so I dig it. But don't lean on the fact that you're good at going off the cuff. You're going to have notes sometimes. The fact patterns are going to be more complicated than this in the future. So definitely build up a robust kind of bullets. Make sure you know your material. And it sounded like you really very much did in this situation. I mean, to be honest, I was surprised. Like, man, this guy hasn't taken criminal law yet, and he's talking like he knows what he's doing. So overall, good job. Don't rest on your laurels. Keep getting better.
Atticus Finch is good company to keep. I like that. But thank you for that, Nathan. Good feedback. Last but not least, Hannah Clyde, one of the witnesses who helped me and Amber on our way to victory in the intramural competition. So,
okay, so I missed the last meeting because I had another meeting scheduled at the same time.
Fine.
So I did my best to find YouTube videos on closing statements. So
okay.
I'm probably missing some knowledge from the last meeting.
It's all right. It's fine. Just go ahead and
okay.
Go ahead and try your hand at it. We'll see what happens.
Okay.
All right.
Ladies and gentlemen of the jury, let's walk through the facts of the case one last time. Lucy Johnson, my client's daughter, heard her parents arguing the morning of March 8th. When she came down the stairs, she witnessed her mother frantically rummaging through a closet after telling her husband to please leave the house. Her father sat physically angry with his arms crossed. He was angry and he was not moving. He was angry and he was not leaving. He was waiting for his daughter to leave before he physically beat my client. My client, a battered woman, was scared. She was frantic. Cindy Johnson was acting in self-defense when she pulled the trigger on the gun. The gun, which was purchased by her angry husband. Even their daughter, Lucy, thought that her mother could not possibly be searching for her father's gun that morning. That was not my client's nature. Cindy had been beat and battered by her angry husband. She was scared. She had not planned to use the gun. It was not her gun, after all. It was his. Cindy, a battered woman, she was scared and she fled. As you recall, she said, "This was all an accident. He attacked me. I had no choice." The investigators are the ones who saw the bruised arms. She was just trying to protect herself. After all, the mailman could hear her screaming, "No, don't do this." She was beaten and battered. She was just acting in self-defense out of fear that she would be beat and battered to death. Ladies and gentlemen of the jury, my client did not act with the intent to kill her husband. She was trying to stop him from beating her, but she did not plan to kill him. The law requires you, ladies and gentlemen, to decide whether my client, a beaten and battered, frantically scared woman, acted with the intent to murder her husband beyond a reasonable doubt. Ladies and gentlemen, my client did not act with the intent to kill. She acted out of fear to save her life. She was trying to flee and she wanted him to stop. And her actions do not make her a murderer. They make her a survivor of domestic abuse. That's all.
I like it. Adam, you have any comments for Miss Clyde over here?
Hey, can you see me? All right. Hey, I thought it was really good. So one thing that I'd noticed lacking really with yours and Matt's and probably everybody's is like a theme, right? Like what is the theme? What is the hardcore theme that you're tying it to? Self-defense, right? I mean, I guess that's the argument, that's the theory of the case, but you want to also have a theme, like what is the jury going to go back there and think about? And so for everyone, you know, to the extent that y'all did an opening and close on these same facts, you know, keep that consistent and come out the gate with it. I think you came out with like, we're going to walk through all this again. And sometimes the jury may be like, I don't want to walk through anything else again. Like I have been here for a long time, so let's don't walk through it. But I mean, I get it, right? You've never done this, so that's the point. I think you did a good job with explaining, you know, the confrontation, the physical confrontation, the fact that she was trying to, you know, free herself and get away versus kill him. You know, I think that was good for everyone, right? I think generally speaking, if you're talking about your client, you need to refer to them by name, and because it always personalizes them. And so it's, you know, what is her name? Cindy Johnson. Miss Johnson was laying on the ground when he got on top of her, and Miss Johnson tried all she could do to get away. Miss Johnson, or Cindy, you could call her Cindy to make her even more sympathetic. Cindy's laying there and struggling, and the defendant kept trying to punch her in the face, and all Cindy could do was try to breathe. And then the defendant stuck his hand on her throat, and all Cindy could do was try to live, right? You're using her name, and then you're talking about the defendant. And so personalizing them, but that's it. I think you did a really good job. And to all of you, continue to pursue this because it will make you better lawyers inside and outside the courtroom.
One of the things, oh, I'm sorry, Seal, I didn't see you there.
Oh, you're fine. I was just only going to mention a couple of things. I noticed that she said beaten and battered like multiple times, and I just wanted to note, even in openings and closings alike, the use of alliteration can be like really powerful. So for me, the emotional appeal and your closing, saying she was beaten and battered, and then saying later, I think it was, you said she was afraid she was going to be beaten and battered to death. And that was like, oh, wow, yeah, you're right. Like that really caught me. And so great job on the emotional appeal. And one other thing I noted was you said, you used some words that I feel like were a little larger or unnecessary, like frantically scared. And like, we always want to talk in more layman's terms, like you're talking to a fifth grader. So frantically scared for me was a little too complex, but yeah, great job.
One of the things, especially going back to you being a witness, Hannah, is that you are able to think on your feet. Like you're able to think quickly on your feet. And that is a skill that can help you on closing arguments. And you showed a little bit of that here. I also want to pick up on what Celia said about the alliteration. Alliteration is very powerful. It's one of the things that I like to do. It's either the alliteration or the rule of three. Those are usually the things that stick in your jury's mind. So if you can, you know, get some kind of alliteration going, and if you can do it in threes even, beaten, battered, bruised, something like that. I don't know. It sticks in your jury's head, and it creates a more effective closing. So, develop the story, like Adam said, put a theme in there, and then talk about the evidence and how it helps your client, and you'll be good. So, but good job, definitely.
Thank you.
I just wanted to point out some to Hannah. Great job. I think one thing missing from your closing that you might have missed from the other workshop was at the end of your closing statement. I like how you wanted to end with a punch, and that's great. Don't forget to make the request to the jury. What do you want them to do on that jury verdict form? Well, in your case, you want them to put not guilty. So make sure that you say that, maybe even multiple times in your closing, but especially towards the end, because you want that obviously to be one of the last things they hear before they go fill out that jury verdict form. Some things I wanted to just point out to everybody is people didn't, this fact pattern, which I thought was one of the worst fact patterns, but that is no insult if anyone here read it. We got better things to do with our time, but
That hurts.
No.
Yeah, it's bad. I know. It's right here together.
No, that was an insult, just by the way.
to the 1Ls, obviously this is a criminal fact pattern, and it's hard enough because you don't understand that yet, but all of you did a great first attempt at it. Some things to focus on. If you look at the fact pattern, it has a ton of just BS in it, and you need to be narrowing in on the objective facts. What are things in there that cannot be interpreted multiple ways? In the fact pattern, it talks about the elderly neighbor. Okay, well, why is that not her witness statements? Why could that be brought in? Why couldn't that be brought in? The mailman. Really, the only objective fact is it comes from probably one of the prosecution's witnesses, which is the investigators who saw the self-defense wounds, the bruising and cuts on the defendant's arms, whatever her name is, Cindy. That's really the only physical evidence that this fact pattern gives you. And how convenient is it that it's for the defense's side? So if you think about this, if we're going to a real trial, okay, the investigator's up on the stand, you're going to have this investigator who is really the prosecution's witness tell the jury that we saw self-defense wounds on this woman's arms. And that is the only objective fact in this case. We don't have gun shells. Actually, if you read the fact pattern, it never says that Mr. Johnson was shot. Never says that. It never says he was shot. So these are things that you want to, as you're analyzing the fact patterns, pick up on, because it could be an issue if you're bringing this to a case and you start talking about the gunshots rang out, bang, bang, bang. Hold up, there were no gunshots mentioned. So just think about those kind of things. Another fact that was maybe a red herring, I don't know. It talks about the gun closet. It says that the daughter knew her dad kept the gun in that closet. It says nothing at all about your client, Mrs. Johnson, knowing that the gun was in there. It never says that. She could have been looking for her other shoe in the closet. She could have been looking for a coat in that closet. It never says that she knew that that was a gun closet. Yeah, I think you you guys did great. I'm so excited to hear you guys for the competition, and I know you guys will do great. And thank you to Wesley.
Tell us how you really feel, Bree. Oof. Nah, she's 100% right, and I left those facts in there, like, purposely. You know, whether or not she knew the gun was in there, or whether or not, you know, there actually was a gunshot. All those kind of stuff was left up to your interpretation, just to see what you guys would do with it. At least that's what I'm going to tell myself and you guys, just to make myself feel better. But yeah, again, thank you everyone who came. Thank you to everyone who tried this. You guys, you know, did great, and I'm looking forward to, if you guys do in fact try out, you know, it'll be a fun time. You know, come in, you know, give us your best, give us your A game, and you know, we'll see what happens. Also, like Bailey said in the chat, don't forget to come watch the open house. Oh, no, come to the open house at Schultz Brow, as well as look at all the videos and the stuff on YouTube. And yeah, it'll be fun. And also, I want to give thanks and a shout out to Coach Adam for coming here and giving us his time. He always does. He's got a special spot in his heart for all of us. So even though he doesn't look like it, he trust me, he loves us all. So
I do, 100%.
okay. So yeah. Anyway, you guys have a nice day, and you know, just if you have any questions, just you know, hit me up, hit Bailey up. Anybody who's you know been here for a while, we'll be happy to answer your questions. So, thanks.